Okay, I think we can begin. Hello, everyone, and thank you so much for joining us today. I have with me Aditi and Nikhil from Yellow. Today, we will be speaking about the fundamentals of making a will and the importance of estate planning. Uh, I'll first leave it to my co-hosts to introduce themselves, and after that, we can begin the session. Aditi, if you can join.
Sure. Thank you. Thank you so much for inviting us over. And thank you so much for giving us
I'm
this
Aditi, sorry,
opportunity.
you're still on mute. Oh, sorry, I can hear you now. Sorry, go ahead.
Okay. So yes, a quick introduction. I'm Aditi Joshi. I'm a lawyer by profession. I have around 15 years of experience in the estate planning space. So prior to being with Yellow, I've been in the estate planning space, and my last stint was at Kotak Mahindra Trusteeship Services Limited. So essentially, we're looking at Yellow. In fact, one of our major endeavors is to bring awareness on this subject matter, and hence we've been ardently and religiously conducted these sessions to sort of bring about that awareness. So with that, Nikhil, I'll pass the baton to you.
Thanks, Aditi. Quick introduction about me. I'm a chartered accountant. The group today has a benefit of talking to a CA as well as a lawyer and answer every queries that you have with respect to estate planning today. By profession, like I said, I'm a chartered accountant. Spent my good part of my career with two of the big four, EY and PwC, and thereafter was taking care of the South estate planning practice for IFL. And I'm the co-founder for Yellow. We started with the idea of how do you democratize estate planning services, which is usually reserved for the cream of the market or the segment to everybody. And that's the whole theory with which, or thesis with which we started Yellow. And and that's a quick background about me. We'll get started with today's session. Yeah.
Amazing. Thank you, guys. Before we begin, I just have a quick poll for everyone to answer because I was curious, and I'm sure you will be as well. Exactly how many of our clients today have a will? So I'm going to launch the poll. You will see it on the screen, and you just have to say, do you have a will? Yes or no? We'll wait for 30 seconds for everyone to give their answer. Oh, wow, that was fast. Okay, so we have 17 people who have voted, and 14 of them don't have a will, 3 of them do. So I think Aditya and Nikhil, you guys have your work cut out. Clearly, many people still need convincing or probably also help in figuring out why they need to make a will. So with that, I will leave it to you guys to begin the session with, of course, the first most important question. Why exactly does everyone need a will?
Yes. Thank you. Thank you so much, Naren. So with that, I'll just share my screen right now. We have a presentation that we'll take you through. All right. You all are able to see my screen, right?
We can, Aditi.
Okay, great. All right. So we'll dive right into this today. We'll talk about what really estate or succession planning is. Usually when you talk about succession planning, people think, oh, in that corporate ladder, who's going to be my next in succession? And when you talk about estate planning, people think, oh, are we talking about real estate? So that's, these are common misunderstandings that we will sort of debunk. So we'll take you to the concepts. There are a lot of misconceptions and, myths in this space. So we'll kind of resolve all those doubts. There are a lot of estate planning tools which are available. So we'll kind of walk you through those, and then accordingly, you can decide which tool suits you best according to your situations. We'll emphasize more on wills today because that's the most fundamental and the most important amongst all the tools. And lastly, we will talk about yellow. We'll take you through the app. And so you'll see how seamless and how easy it is to write your own will. Okay, a quick background for you to understand that why do we really need this whole, succession planning to be done? See, as an individual, especially being an Indian, it's kind of ingrained in us that we need to save whatever we earn. But what really happens is that even though you have the right intention, everything is in order, because you do not plan your succession, your family goes through n number of hurdles, and then the asset transfer that is to be done in their favor can go through immense amount of hardships in the absence of a will. Let's take a look at some hard-hitting facts. In India, approximately 1,50,000 crores of assets are lying unclaimed. And these are only financial assets. We're not even talking about real estate. Unfortunately, 76% of the disputes in India today are attributed to property and family related disputes. And lastly, if everything goes well, that is, if there's no litigation, if all family members are, in good sync with each other, only then it takes around 3 years to get everything in order. Otherwise, of course, if there's a dispute, then there is no time cap that you can place on how much time it will take to complete all the post-death formalities. All right. So let's understand first what happens when you don't have a will, and then sort of, you'll understand the importance of having one in place. So whenever there is any asset, whether it's land, bank account, etc., there are only two ways through which its succession takes place. One is with a will and one is without a will. So essentially, when you don't have a will and when you don't choose, who your assets should go to, the law decides on your behalf. To give you a simple example, if a Hindu male passes away without writing a will, his mother, his wife, and his children become equally entitled to the asset. Now, naturally, when this happens, there are a lot of, the ownership becomes collective. There are a lot of family members collectively owning assets. And naturally with that, there may be some misunderstanding, or so to say, disagreement when one person wants to sell it off, the other doesn't. And that leads to a lot of conflicts. One also important thing to understand over here is that when you don't, write a will, and naturally you need to approach the bank or mutual fund house to get the assets transferred. Now, they don't know who your family members are. They don't know the constitution. So they ask you to produce a lot of documents which will essentially establish who are the rightful heirs which are entitled to the assets. Now, in some places, it's called legal heir certificate. In Bombay, Madras, Calcutta, it's called as letters of administration. Bangalore, for some assets, you need to get a succession certificate. It's called Peri Nama in Gujarat, etc. My intention here is not to scare you off, but the truth is that, different parts of India have got different nomenclatures, but essentially you need to procure these documents, and that is a very time-consuming process. And needless to mention, it's expensive too, and it takes a different toll on the family because they're not able to access the money which rightfully belongs to them. Okay, so let's bust myths today. There are a lot of, again, people have a lot of misunderstanding on this particular topic. So very, first and the most predominant one is that people think if they've appointed a nominee for their assets, they don't need to make a will. Now, there are some exceptions, to this rule. As in essence, your nominee is only a trustee or a custodian, so to say, of that particular asset. Now, like I said, there are some exceptions, but today we'll focus on the general rule. Now, to give you a simple example, if I have a bank account and I make my sister as a nominee, now, if I pass away without making a will, my sister can simply go to the bank, access the money, but she can't spend it. It's actually, as per law, my husband and my children who are entitled to the asset. Now, if my sister does not give the money to my husband and my children, then they can sue her because it is their rightful asset and not my sister's. So, irrespective of, if you've done your nominations, a will is a must. There's also a popular belief that we should make a will only when we're ill or only when we're old, but that's not true. A will is for everyone, and you'll know it by the end of the session. There's one more preconceived notion that a will should be made only by a lawyer. I, being a lawyer myself, I can vouch for the fact that you'll use the Yellow app and you'll see how every single person can create their own will. And the law does not mention that a will only has to be made by a lawyer. And you can change your will as many times as possible. It's really easy, in fact, to change your will. Then it is not true that your will has to be registered or notarized or stamped or on a green paper. There's nothing like that. Coming to the next point, there's also, usually people think that everything will go to my husband or my wife, then why do I need the will? But we've seen that any religion, whether it's Hindu, Muslim, Christian, any religion, it never passes on only to one person. It's a bunch of family members who, obviously, depending on what the family constitution is like, they all collectively, in varying degrees and proportions, inherit the asset. Also, you don't need to be of a certain net worth in order to create a will. You certainly don't lose control over your assets, because a will comes into effect only once you are not around. So until then, you can, change your will as many times as possible. And again, making a will today is not a time-consuming and costly exercise. Nikhil is going to show us a demo in some time, and you'll see how quick and how easy it is to create your will. Okay, so let's take a look at some estate planning tools which are available. So before that, if you've got any queries, any questions, you can either put it in the chat box. We'll obviously pause at the, rather once the session is done, we will dedicate some time to answering questions. Meanwhile, please feel free to post your question on the chat. Okay, so will here is the most fundamental and the most important tool over here. I say that because even if you were to create a trust or you were to gift some of your assets, it will always be in addition to a will. A will doesn't substitute a trust or a gift or etc. Because till the time you're around, you will have some assets for your own, maintenance and upkeep. Because of that, a will is a must. Now, it's super easy to create your will. You need to be 18 years of age. You simply have to put in a plain paper. You write down about yourself, your assets, your family members, who do you want to pass on the asset to. You need to put your wet signature on a will. Digital signatures on a will today is not permitted as per laws in India. And you need 2 more witnesses who will also sign this will. Now, if all these criteria are completed, this constitutes a legally valid will in India. Coming to the next tool. Now, a trust is a little more sophisticated structure. Now, I'll give you an example. Let's say in a will, if I say 10 lakh rupees is to go to, let's say, my child, then immediately when I'm not there, that 10 lakh goes to my child. But, let's say if my child is 16 and I don't want him or her to receive so much amount when they're so young, because they tend to be impressionable at that age, a trust is a good option. I'll explain how. Now, let's say I appoint Nikhil as my trustee, and I tell Nikhil that, when my child turns 18, please give 1 lakh rupees to my child. When my child turns 20, X amount, 25, Y amount. So you can have intermittent payouts in case of a trust. One more situation when a trust can be, appropriate is when there's a child with special needs. Or let's say you have promoter shareholding and you want to make sure that that business succession should happen in a certain way, then too trust can be a good option. Also, if you have US citizenship, beneficiaries having US citizenship, estate duty implications, then trust is good. If you guys are interested in knowing more about a trust, then maybe you can let us know, and we can talk about that in detail, either offline or maybe we can touch upon some aspects later. Okay, coming to a gift deed. Now, gifting is very popular in India. What one important aspect to remember about a gift is that you lose control over that particular asset. This means that the asset stops being yours when you gift it out. It's imperative here to mention the case study of the Singhania family of Brahmins, where the senior Singhania gifted a large volume of his assets to his son. Things didn't go well between them, and now the senior Singhania lost a large volume of his assets because of this, almost to the extent of him not having enough assets to take care of himself. So it's important to understand that you can gift some portion of your asset, but not, of course, a large sum. Coming to joint holding. Now, joint holding may be in the form of bank accounts or real estate. In the bank account, if you have either a survivor option you've selected, then yes, the survivor gets the amount. But after that, what? What about the next in line after the survivor gets everything? However, this either or survivor bit does not apply to immovable property. So let's say if husband and wife jointly own a flat, and if, let's say, the husband passes away, then his mom, wife, and children will get 50% of that flat. So now imagine, instead of just two owners, you have wife, you have mother, and let's say two children, four owners of that asset. So irrespective of whether you have joint holding, it's very important to create a will. And lastly, nomination, though technically is not an estate planning tool, but nominations become very important because asset access becomes easier. You have comparatively less documentation to submit, and time frame wise, it's kind of easier to access the asset. So ideally, going back to the same example, if I have an HDFC bank account and I want my husband to get the money, I should mention his name in the will, and I should make him the nominee, so that whole trail is sort of completed and there's no dispute. If I want, for example, my sister to get it, then I should mention her name in the will and she should be the nominee. All right, we will move on and we'll focus more on the will, and let's see why is it really important to create a will. So we touched upon this, that it's the most fundamental step towards creation of an estate plan. It helps you to overcome or bypass your laws of succession, because these laws are really complex and kind of ancient in nature. The Indian Succession Act, which is applicable to Christians and Parsis, dates back to 1925. The Hindu Succession Act dates back to 1856. Laws have changed, times have changed, but unfortunately the laws have not. So imagine the kind of gap which is there in the times that we live in and the laws which kind of govern us. Creating a will also really eases the transfer to the next generation, because when you have a will, they will not ask you to get a legal certificate or a paidinama, etc., because you've clearly mentioned in your will how the assets have to be passed on. Making a will also ensures that you've clearly mentioned the assets in your will, so that your family knows about the existence of your assets, because connecting it back to the 1,50,000 crores of assets that you saw, it's also largely because children are not even aware of the assets which are owned by the parents, because that clear communication is usually absent. So because of that, will can be very instrumental in making sure that the assets don't go unclaimed and they're not lost in transmission. People also think that if I make a will, then my family members will have some sense of bitterness or there'll be dispute. But on the contrary, if you have a will in place, they will at least know what is it that you wanted. They will have that sense of direction. So it mitigates the chances of disputes when you have a will. When small children are involved, minor children, you must ensure that a guardian is appointed for them. As per law, father is the first guardian and then the mother. But in COVID, we've seen young parents passed away in quick succession. And because of that, either side of grandparents are fighting for the custody of the child. Now, who will know it better than you, who your child is more compatible with? So you must ensure that a guardian is appointed and your children's overall well-being is taken care of. And lastly, it gives you the power of choice. You can choose who is to receive what. There may be some assets which have more of a sentimental value. So you can ensure that those assets, pass on to your set of individuals who will probably realize its value much more than, let's say, any other family member. So you can plan all those things out in the absence of a will. Otherwise, everything gets just divided into the remaining family members, and that's how the succession passes on. All right, so let's take a look at what does a robust will look like. See, just creating a will is not enough. Creating a good will is important. I'll just share, a case we had at Yellow some time back. Children came to us, with a will saying that father wrote all assets go to the mother. It didn't talk about the next in line of succession. These were again COVID times, and both parents passed away shortly within a short span of time. So it all started with which are the assets the father is talking about? What about the next in line of succession? And there were so many other technical issues with that document. But when you create a will through Yellow, unknowingly you just create a solid, robust will, because we take care of several factors which so to say, a common man does not think of. Like, I'll give you an example. We have a role in the will of a somebody called as an executor. Essentially, executor takes care of administration of the estate of the deceased. For example, he is to make sure assets are distributed properly. Of course, there's a lot of other paperwork involved, making sure that returns of the deceased are filed, closing of PAN, Aadhaar, etc. Now, interestingly, as per law, it's not mandatory to have an executor, but if you don't appoint one, then you need to go to court to get someone appointed as an executor. So we not only ask you to appoint an executor, but we also give you prompters to appoint a backup executor, because what if the executor, let's say, passes away shortly after you did, or let's say the executors move to another country because it's preferable they're around so that they can take care of the administration. Similarly with a guardian, not just appoint a guardian, but also a backup. Yellow also factors in many other circumstances. Let's say today, if you make a will, and tomorrow, if you book a fixed deposit, do you need to write a will again? The answer is no, because we have something called as a residuary clause, which ensures that your future assets also will pass on in a certain way. And if you inherit something or there's some litigated property, you get a clear title, all those aspects are taken care of. So with that, Nikhil, I'll request you if you can give a demo of the app and then take it from there.
Thanks, Aditi. And, I see there are a few questions. Naresh, let us know if you think you should address it now, or should we finish a quick, take about 5 minutes and then we can come back.
I would suggest having a look at the questions. It could be related to the section that we just concluded.
Sure.
There's only 3, that's why.
Then let's close it, and then we'll get to the demo of the app.
Of course.
Gautam has a question saying that can HUFs be used to transfer assets to? In a way, yes. What HUF does is that HUF doesn't give you power of granting wishes. right? HUF as a structure is being used only to ensure that assets are consolidated and available to all family members equally. If that's your wish, then HUF is a good vehicle. In our minds, HUF is not a great vehicle to use because it does not kind of give you the power to make distribution the way you want to, right? And once it's already part of the HUF asset category, then it's available for everybody else, and everybody has a stake over it, and that's the biggest part of things. Unless you have another thought process here, Gautam, I think that's the overall disadvantage of an HUF. But yeah, HUF in the past have been used as though it has been introduced in a way, HUF is a trust if you look at it from all perspective, but a specific trust. I'm not getting into details of what a specific trust, what's the discretionary trust, and all of those aspects. But specifically, what I'm trying to say is that HUF, in a way, is a structure that holds the assets for the benefit of the family members, which is nothing but the concept of a trust, but gives you specific rights today so that the beneficiaries can claim their specific interest in their interest within the assets that's housed within the HUF. In the past, HUF have been used as more of a tax planning vehicle so that you can cut down on what do you call the slab rates, etc. You're able to divide it among multiple vehicles. But very honestly, when the more we have interacted with multiple families, HUF has been more of a painful process eventually to wind down rather than provide advantages. I see a second question from Rohan that beyond what net worth does it make? Oh, sorry, I missed the second question. What is advantages, will or settlement deed? Right now, it's all objective driven, right? What do you want to achieve? That's a primary question that one needs to answer. If your intent is that I want to transfer these assets to beneficiaries, then a settlement deed, gift deed, it's been interchanged and used. Settlement deed usually is used in Chennai and other jurisdictions because gifting has a highest stamp duty and therefore use settlement deed, right? But the premise is the same. Aditi did speak about this earlier that when you do a gift, essentially you're losing control. And similarly, in a settlement deed, you are actually passing out your right in the property, saying, I've settled this, and this is how my family members will get access to these assets, right? After that, you can't take it back. Of course, you can talk about conditions and other things. Some of it is legally implementable. Some of it will be good to have factors, but not really implementable. So if your wish is that families needs to get complete access to these assets with zero, limitations with respect to timeline, etc., they do not run around but get access to it immediately, I would look at trust as an option rather than settlement deed, because we don't want to be the next Singania. Of course, but if it's a part of the asset that you want to settle today, but the rest needs to go at a later point in time, then a combination of settlement deed and a will also can be looked at. It's very objective driven. Really, there's no straightforward black and white answer here. We can perhaps understand what your objective is and see if settlement deed really meets your requirement. We have another question from Rohan that beyond what net worth does it make sense to use a trust due to paperwork cost involved? Is it recommended as a risk mitigation plan to avoid succession tax? See, it's yes and no. When we look at trust as a structure, net worth is not the first criteria, right? Trust as a structure is to see what is your objective again. It all boils down to that, saying, what do you want to achieve, right? If your intent is that I just want to ensure families needs to get access to the asset, a will actually do the job of transferring assets because the wishes are casted, etc., and what all of those are taken care of. But the aspects that Aditi earlier spoke about with respect to saying that, I want quick transfer of assets, I want to plan for estate duty, succession tax, inheritance tax, whatever nomenclature that is, or I want to ensure that I want to ring fence my assets from any potential liabilities. I want to plan for incapacitation. I want to ensure my, through a will, assets go as a bullet payout to beneficiaries, which would mean that, if you have minor kids, or even if you have kids at the age of 18, 19, 20, they get access to these assets And is that the right timeline when, or the age bracket when they should have access or complete access to these assets? Do you want to stagger these distributions for a later point in time? If these are some of the, objectives that you want to look at, even cases like, should my extended family have access to these assets? Can I keep it only for my bloodline? If these are some of the objectives that you need to achieve, then you should look at trust as an objective. I'll give a simple example here. The reason why I'm not stressing, of course, with if I have to put a broad, value standpoint, if you're looking at anywhere about 20-25 crores, you could look at trust as a trust structure. Purely from a number perspective, it makes sense from creation of the trust plus some bit of maintenance. The maintenance is really about whether you appoint a professional or an trustees which is within the family. Then the cost is not much for the maintenance. But for the creation, etc., you could look at this as a broad parameter. But I can give a perspective, right? As in, I had a client whose net worth was under 8 crores. But the reason why they looked at trust is because they were elderly family, as in husband and wife of about 65 years old. They had an adopted minor child who was 14 years. Now their concern was that I don't, if something were to happen to us, I don't want my minor child, one, guardian could misuse potentially the assets. So therefore, want to ensure that her lifestyle education is taken care of. Only once she attends, say at 25-30 years, is when she should have access. And he also had a charitable organization, an NGO, where he said part of the incomes arising from this mandatorily has to go towards the main upkeeping of the NGO. Right? If some of these objectives, now it's not really a wealth filter, but more objective, because with a will, this is not very unlikely you can even achieve, rather it's impossible to achieve this objective, and therefore trust made complete sense for them. I hope I gave you a good perspective, Rohan, with respect to when would one look at trust. Now, Vikas has a question, why will registration is not mandatory? If we can, how can we register? Aditi, do you want to pick up this question?
Sure, Nick. Okay, so Vikas, essentially, if you look at the laws in India, only anything to do with immovable property, in a sense, the registration thereof is compulsory. So all other documents are they're non-mandatorily registrable. But having said that, even though it is, not mandatory to register a will, registration has its own advantages, especially if you're dealing with any immovable property in your will. Now, why is that? Because, firstly, you can go to the sub-registrar's office, which is your regular guy where you get all your immovable property registration done. Same place, sub-registrar's office, you can go there and get your will registered. So essentially, you're signing before the sub-registrar. So it's almost like he's witnessing signing off on the will, which shows that you're of mentally and physically, you were stable and there was no external coercion on you to create your will. But from a practical standpoint, in certain places, at the time of asset transfer, the local authorities tend to rely more on a registered copy of the will. And that is why we, recommend you that if there's any immovable property involved, you get it registered. It's really easy. It's also not very expensive to get the registration done. And Yellow helps with registration too. So in case if you want any help from us, you can let us know.
And your question of how can we register, you just need to go to sub-registrar's office, like you do a title deed registration. Is of course is not under the same category, but the process is the same. You go up, get your thumbprints, taken care of, photographs, etc. On a lighter note, if it's a investment that you do through Strata, then probably this is something which you don't need to look at. Though you have participation in movable property, you're really not dealing with sub-registrar for asset transfer. Now, Dharmesh has a question. List of assets can be dynamic while testator is still economically active. How does one make sure the will remains relevant? Great question. Once I go through the demo of the app, I'll give a perspective. But Aditi also did address about residuary asset. It kind of gets addressed. We will touch upon this part specifically, Dharmesh, when I do a demo of the app. Roshan has another question. Can guardians and executors be the same, or they need to be separate individuals? Aditi, do you want to respond to this? And he also has a follow-on question. In what circumstances a will can be disputed? How are creditors treated towards their ability to challenge a will? Are wills attachable by government agencies? Are wills legitimately enforceable if it was created outside India? Great questions to you, Aditi. Go ahead.
Thank you. Okay, firstly, Roshan, yes, the guardians and executors can be the same, but we recommend that, you can have different individuals as guardians. But of course, there is no embargo as per law that they should be just, all separate people. Of course, if, you're one person you trust and you think that they can sort of, carry on these multiple roles, then it's completely fine. Coming to the next question, essentially wills are disputed on on the grounds that the will was fraudulently made, or that the testator, that is the person who created the will, did it out of force and pressure, etc. Now, we will be sharing with you shortly a couple of tips on how we can increase the robustness of a will. But to answer your question, I'll just touch upon a few things. One is you can get your will registered, because that will add as an additional layer of protection. You can video record the will so that it's all on record how you've created it. And so if you sort of take care of these little aspects, we can make sure that your will is a robust one. Now, you're coming to the next one. How are creditors treated towards their ability to challenge a will? Are wills attachable by government agencies? Okay, essentially, the basic rule is that whenever there's any estate and the beneficiaries have to receive any benefits, always the liabilities have to be paid off first. And then only the distribution of the assets will happen. So in case if yes, there is a debt which is there, then definitely the government can take on the recovery proceedings to sort of recover that assets. So they are not like so to say insolvency proof. If that is what you're looking at, then probably trust is an option that we can again connect offline and try and see what is it. To give you an example, see, even under the insolvency code, if a structure is created 2 years prior to that particular bankruptcy event, then maybe it may be a situation that your assets may be sort of not be considered as a part of your other estate. But again, like I said, there are other couple of factors involved, but yes, we can connect offline to if there's a financial exposure that you're envisaging, how we can sort of help you. And coming to the Nikhil, you want to add something to this?
No, finish it, and then I'll probably add on a couple of points. Yeah.
Okay. And if wills are legitimately, so okay, your question is, are wills legitimately enforceable if it was created outside India? The answer is yes, you can create a will from anywhere, but there are 2-3 things again to remember. We always recommend, if you have assets spread across multiple jurisdictions and countries, create a separate will for those assets, because enforcing of a will created outside in India has certain procedural aspects. So it may take more time than a usual Indian will to get enforced. So for that, the answer is yes, essentially it can be enforced, but of course with additional laws and processes. Yes, Nikhil.
Yeah, sorry, maybe I'll be shooting in my own foot here, but your broad question saying in what circumstances a will can be disputed. The undisputed fact here is that any document can be contested in India, right? But what is more important is to say that even if it gets contested, of course, that will delay the whole timeline of when the families get access to the assets. What all you build as a backup so that your family tomorrow can prove that your will was actually the genuine will, and that needs to be given effect to plays a much broader role. And that's something which we'll talk about. What are the good to have situations to make the whole will much more robust. And yeah, that's broadly it. And I'm sure the point of attachment with government agency, etc., you're looking at it post demise. But if you're looking at something during life, will is a document that comes only post, or gets given effect only post demise and not before. And therefore anything that you do during life has no relevance until the event of demise arises. And the last document that you write and provide wishes, that becomes the document that gives complete decision on, or direction on, how the asset needs to be distributed, including the possibility of government and other credit agencies looking at what are the asset situation, how much liabilities are there, and what is remaining which needs to go to the beneficiaries.
We have one last question, Nikhil, if you want to pick that up.
Sure. If one child settle in the US, how does will versus trust equation look? See, there are multiple things here, right? A child settling in the US is first thought process to look at a trust as an option itself, because US has estate duty. Unlike India, though it was there in the past, it got abolished because the income or the revenue generated by the government was not commensurate to the efforts that the government had to put to really recover those. Essentially a loss-making business, right? But today that may not be the situation. Today, with the way digitally details are available for the government, it's a matter of time when an estate duty law could be introduced in India. That saying, having said, US already has a estate duty implications, right? If you are a Indian resident and your kid or your child is settled in the US and receives these assets from you, is there an estate duty implication? The answer is no. But what happens is that you're only deferring the problem, right? Once your child gets these access to these assets, it becomes part of their balance sheet. And thereafter, when the assets needs to move from your child to the next in line, with is the future generation, at that point, an estate duty implication will trigger if the values of the assets breach a certain threshold. Today, the threshold is 12 million. It could come down to 6 million in 2026. And these are moving numbers. What is relevant is at that point in time, what is the number? Does it meet the threshold? Then you need to cough up 40% of your overall asset. I'm not talking about 40% of the income. It's 40% of the net assets, right? Net asset essentially is gross asset minus liability becomes your net asset. On that, 40% have to be paid to the government before it can be passed on to the next in line. So therefore, if value numbers are high, you want to plan for some bit of tax arbitrage for your US child to the extent possible. It's not a permanent solution. At some point, arbitrage is possible. If all these are objectives that you want to meet, trust becomes an effective vehicle. If you think this is not something, your values don't look at breaching these numbers, it doesn't matter, then will is a good direction to look at. When you look at values, you don't look at current value. Look at what this value could be if in the future, right? Anywhere, if you look at a broad parameter, in a decent investment, you will anyways double your assets in 5 to 7 years. And that's something you need to see where this asset values could be. And if it's really going to be substantial, that can impact estate duty implications in the US, then it's a good way to start a trust structure today. Because once it goes to your child's name, there's nothing much, or rather the flexibility is hardly anything. With you in India, you could perhaps create a very, very, efficient structure so that you can probably mitigate the entire estate duty implications in the US. Sudarshan also has a question. I think these questions will keep coming in. Should we do continue with the presentation and then come back, Naresh?
I agree with you, Nikhil. Folks, do post your questions in. I think some of them.
Yeah, here, and we will answer all the
Yeah.
questions today before we log off. So let's kind of complete the presentation and come back.
And Aditi has answered Sudarshan's question, so it's fine. We can continue.
Great. Perfect. So what I'll do is that I'll quickly share my screen for doing a quick demo of the app. Just 1 second. let me know if you're able to see my screen.
Yes.
Yes.
Okay. So this is our app which we have built out to ensure broadly the importance that Aditi mentioned in the earlier part of the presentation is that you don't need a lawyer, you can do put together your will on your own, and that's the tech platform that we have built. This screen that you see is essentially something which would be relevant when you already have created a will, because there's a demo screen. But having said that, when you probably download the app and play around with it, the screen will be a little different. But net you'll see continue my will, but you'll say start your will journey here, right? You also have good amount of literature with respect to how to create your will, various aspects of some of the aspects that we spoke about today, good, crisp, not technical blogs, so that you can read and understand what are the various scenarios that one could look at, a good FAQ section to understand what are the each of the role players, etc. But having said that, what we have done is that we have kind of removed the entire legalese of will creation and made this whole process a what do you call, a journey of talking about your situation, right? What we've done is we have split it into 7 cards, each card talking about various scenarios. Card 1 talking about your personal details, card 2 talking about various members of your family, friends, etc. What are your assets in card 3? How do you want to distribute these assets in card 4? Who is the executor to your will? Guardians if you have minor children, and witnesses to your will. Once you enter these information without any legal aspects of things, your will gets generated, and very simple way, just generate your will. It hits your inbox, download, print, sign along with 2 witnesses, it becomes a valid document. Now, what is the various details that you need to capture? If you go to my personal details, you are essentially capturing some of your data, your information, right? What's your name, gender, date of birth, phone number, etc. Many of these you'll see in asterisks, or rather few of this you see in asterisks, many of it in non-asterisks. Asterisks are more details that is mandatory not by law, but from various from the experience that we have in this space, we thought this will help you, because tomorrow you don't want someone to dispute saying, was this the right person who created the will, right? So these details help. You can also do a KYC, again not a mandatory field, but KYC helps because tomorrow when you take your documents to the various authorities, you also submit your PAN, Aadhaar, etc. And if there's a difference in the name, there becomes an issue, and you could perhaps conduct your KYC through the app process itself. Once done, the next, it's a continuous process. You can get to the next screen by just saying next. Here you go into My People card. Here you can enter details of various family members, your child, friend, spouse, beneficiaries, whoever, various role players that you need to capture in your will. It's not necessary that all of it have to be captured here. You can also capture their details along the way, but this is a repository of all My People. It's very simple how you can capture details of your people. You can add the details of the person either from your contact, because some of the information is already there, it gets auto-populated, or you can manually capture the details of my person. If you see here, you can see asterisks, name, gender, and the phone number and relationship are the only mandatory fields that we are asking for, because that helps establish one's identity. And beyond that, of course, you have optional fields where you can capture details of their ID proofs, address, and whatnot. These are optional. Good to capture information, not mandatory. Once you have done capturing the details of My People, the next section is more about estate. We have taken the pain to kind of list out more than 35 plus categories of assets, ranging from real estate to movable assets such as your jewelry, artifacts, and whatnot, right? Even here, the premise is pretty much the same. Combination of mandatory versus non-mandatory fields. The important point here is that we don't require you to capture value, right? Again, you don't need to use our app. We are giving you a perspective of saying how you need to go about getting your will done, right? And you'll get a perspective. If you want to draft it on your own, you can do it. If you know, more than happy to use our app as well, right? But again, the point here is more about capturing identifiers to your asset, because what is more important here is that you can draft a will, one pager saying all my assets goes to my spouse, but it really doesn't help, because does your spouse have complete visibility of all the assets that you own? And that's the reality. I can, stick my neck out and say not more than 5% of the audience group here could have given some visibility to your family members about the assets that you own, right? In many a case, it is not. And that's why there's a staggering 150,000 crores of unclaimed assets in India. So here again, if you look at residential properties, you can capture what is the nature of the property. If you see some asterisks in terms of the address, etc., of course, you can capture Khata number, survey number, details. Simple things that we have added here is that you can also capture details of extract of property document, so that the more you provide data, the ability to crystallize on what the asset that you're talking about becomes very clean. The same is the case with other asset categories, be it commercial or agricultural land. Now, financial assets, again, we've split it into multiple parts: bank related, which is bank accounts, savings, current and recurring deposits, etc., fixed deposits, and financial investments otherwise, with respect to, if you have a wealth manager, if you have demat account, if you have mutual fund investments, bonds, ESOPs, securities, investments in fractional real estate like starters, all of those can be really captured. Various categories are available: insurance, retirement funds, and any other financial assets that you own can be captured here. Again, all that, if I have to give a quick demo of bank account, for instance, all that you need is name of the bank, which branch, account number. Again, account number, all these are alphanumerical. You can say ending so and so. So long as you're sure that these details will help your family to identify the assets, that's good enough, right? Capture that. For financial assets specifically, you could add nominees. And point of contact becomes very important, something that you may consider, because you may have relationship managers. And tomorrow, if you're not around, your family members could perhaps reach out to the point of contact to get some of these assets, because they have some background about what is happening with respect to your accounts, and they may perhaps help them with the overall transfer process itself, right? Moving forward, apart from financial assets, you also have business assets with respect to proprietorship, partnership, company shares, etc. That's something can be captured. Digital assets with respect to, if you have crypto portfolio, e-wallets, e-gold, etc. All of those can be captured. And other assets with respect to, jewelry, watches, any other categories of assets. What you've done here is that for each category, you have options to take a picture, especially for movable assets like this. For instance, say I have a jewelry. For instance, I'm talking about the our conversation. I'm just taking a picture here. This, once taken, it gets appended as part of it. You can easily itemize your assets, say who should it go to. There's no confusion, because you can say my jewelry, which is a ring, needs to go to my spouse, or and my other ring needs to go to my son. Right now, how do you differentiate between what is this, each of these assets? Now, you could also say my assets go 50-50 between my two children, right? How do you divide the assets? Do I, break the bangle into half, or how do you kind of distribute it? It becomes a reason for a conflict. You can itemize it easily, provide specific wishes for each of these asset categories, right? Once it is done, you can move on to liabilities, capture the details of any liabilities that you own. Again, not mandatory, but like Aditi said, by law, assets needs to be distributed to beneficiaries only once liabilities are paid off, right? Once that is done, you come to the next screen, which is nothing but distributions. Here you can go, if your wishes are very simple, all my assets goes to my spouse, then you could check all the assets in one go and give a one-time quick wish and move on. If you want to go individual asset wise, you could always do that. Here again, it's very simple, very intuitive per se. Is that you see here we have divided between two person. You can always say one person, remove the check mark and add the person. You can also add anybody else you want to add. Just select the person, or like I said, you can always add new person at any interval and any card, and add the person's details, capture it, assign a percentage, need not be equal. It can be 30-70. It's whatever you want to capture it, say next, and you're done. That details gets captured. Right? It's as simple as that. Once you capture the details of your primary distribution, or who are your primary beneficiaries, very important to capture about residuary asset. One of the questions was about saying my assets are dynamic. How do you ensure assets there will be change, and how do I ensure my will is more current, right? One way to do it is capture your wishes to say that my future assets or assets that I've forgotten, how do I need to distribute it? This particular clause within the will, which is also part of the app, will give you a perspective of how your asset needs to be distributed with respect to assets that you're not captured. Of course, it's not a good practice to leave everything here, because you're coming back to square one, saying, do your family have complete visibility of what those other assets are, right? As in when the delta of asset change increases, it's good to always go back and update your will on a regular basis. Good to, in our mind, it's good to always at least look at your will every 1 year. If there's a good change in the asset or family situations, look at updating it. Moving forward, you capture the details of residuary asset, how the wishes needs to be captured. And then we don't stop there. We also capture situations saying that if I've provided all my assets needs to go to my spouse as an example, what happens if my spouse is not around, right? We also need to ensure a contingency needs to be planned, so that the end objective is that at no point you should be visiting a court to get your assets distributed, your families, right? And therefore, providing contingency with respect to what happens when the primary beneficiary is not there is a good way to kind of address it. Here again, we have nudges with respect to how these assets needs to be distributed. It could go to the lineal descendants of the beneficiary, or to remaining primary beneficiary, or custom distribution you could assign whoever else, or even charity is something which you could provide for and add the details of the charity. Right? At every card, you have this question mark, and usually a first-time user, this always pops up. You can get a perspective of what each of these card means. But at any point in time, if you want to explore further beyond what is provided here, you can explore the FAQs, and you can always chat with the customer support to get a perspective or ask some of these questions. And if things are technical, they also set up a call with a legal expert with in-house, so that your queries gets addressed. Now, moving out of distribution, the next card is executor to your will. Again, simple selection of who your executor could be. You could also have a backup executor. If I were to show it quickly, I can remove this. Usually it showcases this way. I've just removed a backup executor now. Yeah, now you see the backup executor card is empty. Good to have a backup executor, simple, add your backup executor, and that's done. Move on. You can add any number of backup executor. It doesn't stop at one. You can add more than one. The idea is not that both act together. It's only when the first person is not around is when the second person gets added as a backup executor. Again, if you have guardian, if you have minor children, appoint guardian to your minor children. Again, you can, similar to executor, have an option to appoint guardian. Again, backup to the guardian. Essentially, it's situations of saying that it's not about the person doesn't want to take up. That can be a reason. We have seen situations where they don't want to take up the roles, but also situations could be that they also, they didn't survive the execution of this will, or could be situations where they moved out of the country. They're in different jurisdiction, which makes no sense for them to spend time and effort here, or maybe they're old that they don't want to spend time, right? In those scenarios, it helps to have backup so that you don't have to go to the court to get the new executor or the guardian to be appointed. Now, once the guardian is appointed, the last card is nothing but witness. Here you have an option not to add, or you could add, who your witnesses are. You can add the details of your witnesses. And once done, you have funeral wishes. It's an optional field. You want to capture, you can capture it, or you can skip. Once you have basic parameters captured, a preview of a will automatically get generated. The first time when you enter, you won't be able to see a preview because there's no details. And this gives you a perspective of how your will looks. It's very current. Whatever changes you do is pretty much available for you. Once you're good, all that you need to do is click on generate will. If you're not completed KYC, the KYC needs to be completed, or you can skip it and confirm details. Once that is done, your will is generated, it hits your inbox. We also, depending on the plan that you choose, we also have an option to send it to your we can print it and courier it to your address. And all that you need to do is sign along with 2 witnesses, becomes a valid will. Yeah, that's a quick demo of how simple it is to create a will on Yellow. Going back to our slides, some things that we did leave it for a later part, saying what are the ways we can make the will robust. If you see some of the aspects that were captured in the will journey itself, you have seen nothing legally. It's more about capturing your life situations. By doing that, you're automatically, without your knowledge, you've created a very robust will. But beyond that, that's one thing that you've done, is created something which is robust. But to give effect, like I said, you have to sign it with a wet signature, because digital signatures are not valid in India. Once you have done, along with few good to have practices, your will becomes much more robust, so that even if it gets contested, we can't avoid contestment if somebody wants to contest, but these backups will help families to defend your will should the situation of contestment arise. The must-have situations we have already addressed. Happy to address those questions specifically if you have anything. But good to have situation is to one have a video recording of your will, which essentially would ensure you read out your specific wishes along with signing the will along with 2 witnesses, all in one take, not multiple takes stitched into one document that may not come as a good evidence. Interesting fact here is that Delhi High Court, in case of one of the families, they didn't have a copy of the original will, but they had a video recording, and basis that they've not disregarded the existence of the will, and the matter is now pending with the Supreme Court to ensure that whether this can be taken as a valid proof to ensure that is the document. Though the document is not around, the video recording should be looked at as a valid will. Doctor certificate is another way to kind of make it robust. One of the points that Aditi mentioned earlier is that your will can get contested on the grounds that you're not in right mind frame or sound mind when you wrote the will. A doctor certificate on the date of signing the will help establish this aspect that you were of sound mind when you wrote the will, so that tomorrow nobody can contest on those aspects. Registration, I think we spoke about quite a bit. But again, registration gives you one additional witness, which is nothing but the government, and usually recommended when you have immovable property. A few other points that we talk about here with respect to keeping your ID proofs, etc., updated. You may think it's very basic, but we have seen situations where families have 6-7 versions of names in multiple documents, and that becomes much more complicated for families tomorrow when they need to execute the document, right? It's good to align when things are good. That's the right time you can go back and kind of align your documentation. It's not difficult to amend some of these ID proofs, and easily can be done. And that will kind of ease out many of the difficulties or time delays with respect to gaining access to the assets post demise. Update your will from time to time. We spoke about it. Good time frame is at least pay a visit to your will every year, if not before. And if there is situations which demands you to update either asset details or family situations, it is a good red flag or a trigger for you to update your will. And most important point, last but not the least, is keep your family members informed about the existence of a will. Because if you don't do that, all the effort that you've put together to create a will can go completely wasted, because unless they know that there exists a will, how do they even give effect to it, right? And good to have those information with the family members. Sometimes family dynamics may not let you disclose this information. At least the executor should be aware of it, so that when the time arises, they can disclose the information about an existence of the will. And one last tip before we shift from this slide is that usually families think that the will is a very important document, needs to be saved in a extremely safe environment and store the documents in a safety locker in a bank. That's the last not a good practice to have, because it becomes a chicken and egg situation, because for you to access the bank locker, you'll have to produce a will. You may not have a copy of it, and therefore not, you're not in a position to access the document. So keep it at your home, in a cupboard, or with a trusted person, but not in a bank locker. Yeah, about Yellow, I think now you've seen the app, so I don't need to deliver much about it. But having said that, the app itself is 100% legally valid. You've seen how user-friendly it is. But while we don't take any sensitive data here, no values, no IDs, no passwords, it's more about identifiers for your family. But having said that, we have gone beyond what is needed from a security protocol to ensure all your data is fully encrypted and all your personally identifiable informations are saved in a separate zero trust vault, so that if there's a breach tomorrow, which is they need to breach a Google server, cloud server, before they can get access to it. Even if they were to do it, they need to breach another zero trust vault to match data to make sense of the data that is there. And end of it, I don't know what they will do with that data. But having said that, we have taken complete care to ensure that is there. Updating will is very simple through the app. We know that it can't just be, of course, it's intended to be a fully DIY app, but having said that, you have access to lawyers in-house if you have questions that needs to be answered. But we have not stopped at only creating a structure that helps families during life, but we also go the extra mile to also help families to with the recovery of the assets or transfer of assets post one's demise. So we act as a single window solution for transfer of assets, so that you don't have to deal with multiple agencies, regulators, getting your legal heir certificate, succession certificate, whatever those documentations are there. We do entire work on your behalf, take up the entire bandwidth, and provide to the extent possible, a doorstep delivery for overall asset transfer process for your family. Of course, why we are capable of doing this is because we have spent enough time in this space. Me, Aditi, and other faculties or members of our team have combined experience of more than 50 years in this space and helped multiple HNIs, ultra HNIs protect more than 42,000 plus crores of assets for their families. And then the next two slides are more about the app as well as the post-demise coverage. We can skip that, Aditi, you can see the kind of work that needs to be done post-demise. A host of things. We do an entire blanket of services. You can also pick and choose with respect to what help that do you need, and we are more than happy to do that. Moving on, how can you access Yellow? Create Your Will is extremely pocket-friendly through our app. At $8.99, you can get your will done fully DIY. But if you need a lawyer support along with the creation of the will, get on a one-on-one VC or a phone call. That's at 1,999. That'll ensure your wills are taken care of, and if you need registration, etc., that's an added cost depending on the jurisdiction. With respect to Smart, which is our post-demise coverage, there are two options to avail this. One option is if an event has already occurred, we can help you there. We can understand the complexity and see what is the efforts involved and provide you a quote. If it's fine, we can help you with the overall transfer process. But the second option is during your life, you can ensure, like your life insurance, capture, subscribe to our Smart plan. It varies depending on the age. And if you're an active member, should something happen to you tomorrow, your family can get access to entire Yellow suite of agents on ground, which is 500 plus agents today, and the group is increasing. And that group will help your family with the overall asset transfer with zero out of pocket from your families. Yeah, with that, we can go back to questions if there are any. Some of the organizations that we work with. Yeah. You can scan
amazing.
the QR
Yes,
code
yes, sorry.
to quick, download the app. But we'll also ask, Strata Fraternity to also share links of the app so that the group can download it and experience it. You don't need to pay for the app to download the app. Experience it. If you think you like it, only when you generate your will is when you need to make a payment.
Amazing. Thank you so much, Nikhil and Aditi. I think we are open for Q&A. So folks, if you have any more questions, please do drop them in the Q&A box. In the meantime, I just wanted to thank both of you guys. A very interesting session and also a lot of interesting anecdotes, especially related to cases that you have seen in the Supreme Court or in other high courts. Especially, I was quite fascinated by the story of the Singhanias. When it broke out a few years ago, it was simply a story of a son not being really faithful to his dad. But with what you shared today, there is more information that I've gleaned.
Yeah.
Uh,
No, it's a
Fascinating.
situation of how one could at some point in your life you're very gullible, and not gullible may be a wrong terminology to use. You are kind of you can be influenced, right? You think
Correct.
this is the right move to do, and that's not the right time to make a decision. You could make decisions when things are extremely going well. You are in a right thought frame is when you need to start making decisions. And will is such a simple document, can save much more of these painful points which nobody thinks about.
Got it. Amazing. I'm just curious. I'm sorry. Before that, I'll just answer Gautam's question. Yes, Gautam, we will definitely be posting a recording of this on Strata Circle, so that you can follow up and look closely at Yellow's advisory. I was just curious about one more thing. Who was the youngest ever person you've had who has made a will? Did you have someone
In
who's
our
18
app,
years
it's
old?
23 years.
23 years.
In our
Amazing.
app, it's 23 years. By law, it's 18 is what you can what is the minimum age bracket where you can create a will, because law respects 18 years plus as a major, and that's when you are in a position to write or enter into a contract.
Got it. And since I asked the youngest, I have to ask who was the oldest person ever to make a will
3 is
with Yellow?
common, but 9 and 2 is the differentiating factor. 93 is the highest age bracket.
Oh my God! Wow. They made the will when they were 93 years old.
Yes.
Fascinating.
Now I'm not sure if the gentlemen themselves did it or their kids would have helped them create the will through our app. But we don't read the data, right? We know metadata,
Right.
and we know that age bracket of users, how they've created, who created, etc., is something which we won't have data. But we know there's a 93-year-old person, gentleman who has created a will through our app.
Got it. Looks like Pradeep has a question, so maybe we can take that.
Sure.
Do you support will writing when the assets are in India and the United States, and beneficiary is a US citizen and Indian citizen?
So Aditi did touch upon this point earlier, that there's nothing that stops you from writing one global will for all your global assets. But practically that's a pain, or rather a execution nightmare for families. Good to have separate will for multiple jurisdictions. In your case, asset in US, asset in India, families have legs in both jurisdictions. Good to have two separate wills, one for India, one for US. Our expertise stops at Indian assets, but for global families. So we stick to what we know well, and that's where we stop. Luckily, there are similar counterparts of ours in the US. We can name a few if, I don't want to put it out here, but we can share some details with you, Naresh, which can be shared with the group or with Gautam if he needs it.
Sure thing. Perfect.
Similar
Before we
platforms
go on to the
who are
next
doing
question,
experience.
sorry. Before we move on to the next question, I just for the benefit of everyone here, I'm sure that while many of our clients would find use with Yellow's will making services, I also feel that your estate planning service is something that our customers should really look at. At Strata, or most of our clients are privileged to be wealthy, and they have significant assets. And I feel that your services would be of great use for them, especially in execution and real estate planning. Sorry, not real estate planning. That's our business. Yours is estate planning.
Estate planning.
Of course. Roshan's question is quite extensive. Can you share a story of a customer who has used the premium services and how you have seen the impact such service quality won't be seen by will creators? Hence the question for the survivors to know the quality of service they can expect from Yellow.
See, how do I put this, right? We are a startup, and therefore, fortunately or unfortunately, we don't have a situation where people who have created a will with us, at least the premium service, have passed away. We have situation where person who have created a will had passed away, and we have provided whatever details that is needed to the family, but not the elite a service that we have where we help with the overall asset transfer process for an existing user. But having said that, have we helped families with post-demise asset transfer processes? Definitely, many of those scenarios we helped with obtaining succession certificate, transfer of property. Aditi is currently dealing with a UK family whose grandmom passed away in Navsari, which is in another tier 2 town in Gujarat, where we are helping with the overall property transfer, where families no need to step foot into India, and we are getting it done for them. So especially NRIs, etc., where they are remote, we our post-demise coverage really helps them, because they don't need to spend time and effort in India, and we do the entire runaround for their family. And one point here, Naresh, thanks for highlighting it. While we do this entire aspect of will creation, etc., digitally, we also provide offline boutique estate planning services, especially creating trust, etc., for families. And that's something which we evaluate on a basis, time and effort, that is on or complexity of each family scenarios. And that's the expertise me and Aditi bring onto the table, because we have dealt with multiple families. I can't take names here, but the who's of India we have worked with, and that kind of gives us the wealth of knowledge with respect to dealing with not only Indian situations, but also families who are spread across the globe. How to plan for it is something which we are capable of handling.
Nikhil, I think Roshan has a follow-up question. He wants to know.
I'm not able to see any questions. I don't know why, but yeah.
Okay, so Roshan's asking, could you be more clear about your expertise in handling overseas assets access for surviving family members?
So simple point here, right? As in, say you have family members outside, you are you are living in India. When you're not around, your assets needs to be accessible to your family members overseas. Now, if you have real estate, for them to actually get access to this asset, they need to come to India, go to the sub-registrar, get the assets transferred to their particular name if they're not in India. Now, how can we help? Is that if you have family members, we don't take POA, but with the help of POA and doing the entire runaround, there's no timeline in terms of when they need to be here. I can give an example again, right? What Aarti did speak about this particular client of ours, whose parents wrote a will. Both good part is they wrote a will, but the bad part is they didn't write a efficient will, which essentially would bring down to the part that this gentleman who's our client, he is at a senior position in one of the tech companies in the US. He had to spend 6 months in India to figure out where the assets, what are these assets, and then go get a succession certificate done and all of those things before asset transfer could happen. Perhaps at that point in time, Yellow was not in existence, and we could not help him. His only point is that hope you guys were around. You could have done the entire runaround so that I don't need to spend 6 months in India. I could have continued with my job, no opportunity lost, but you'll take care of the entire work here. I hope that answers how we help families overseas with respect to asset transfer.
Roshan clarified his question is more to do with assets that are based overseas.
We don't help with assets overseas.
Right. Got it. If there are no more questions, and folks, if you do have questions, please post them. Don't feel bad about interrupting me. I just wanted to again thank both of you, Nikhil and Aditi. And folks, if anyone is interested in checking out Yellow, their website is getyellow.in. You can, of course, reach out to them on their website, phone, WhatsApp, or email. We will be putting the link to this webinar and a link to Yellow as well on Circle. And we'll also look into maybe bringing on Nikhil or Aditi onto the Circle platform so that they can also be there and answer your questions whenever you want them. With that, thank you so much, everyone, for signing in. And thank you, Aditi and Nikhil, for taking the time to answer all these questions and walking everyone through the importance of wills and estate planning.
Our pleasure, Naresh, and thank you everyone to carve out time on a Saturday evening. I know everybody has plans, but this is an important topic, and glad you could make some time to hear us out. Hopefully, we've given you some inputs with respect to how one could easily create a will, and you don't need to park this in the back burner anymore. You can get it done in no time.
Amazing. Thank you so much, everyone. Have a great day. Bye.
Thank you. Thanks. Bye.
Thank you.